Ron Reese had poured everything into a commercial development project, maxing out credit cards and personal loans to keep the vision alive. When the commercial project ultimately collapsed, he was suddenly left holding a massive, crushing amount of personal debt. The debt collectors called so frequently that Ron began to recognize them by name, almost as if they were invasive members of his own family. The threat soon moved from the phone to his front door. He faced the very real legal prospect of losing his house, his car, and even the basic furniture inside his living room. Systemic debt collection relies on this high volume of relentless pressure, attempting to wear down an individual until they submit out of sheer exhaustion. When the summons eventually arrived, Ron prepared for his first day in court by putting on his oldest, most faded jeans and a pair of broken sneakers. He believed that by physically displaying his financial ruin, he could force the magistrate and the opposing attorneys to take pity on his situation. The legal professionals in the room saw him as a wet rag doll. To them, he was simply an obstacle standing in the way of a financial recovery. Courtrooms are built for cold financial extraction. In this environment, relying on the compassion of the system is a losing strategy. Over the next 2 weeks, Ron realized that continuing to blame the bank for his ruin would only solidify his status as a failure. He adopted a specific definition for the anxiety paralyzing him: fear as false evidence appearing real. On his next court date, Ron arrived early, dressed in smart clothes, and stood upright with a deliberate, focused posture. When a creditor's attorney approached him in the hallway demanding an immediate signature on an acknowledgement of debt, Ron looked him straight in the eye and refused. This refusal disrupted the expected predator-prey dynamic. By matching the attorney's professional posture and tone, Ron forced the interaction to happen on his own terms. While waiting outside the chambers, Ron listened to the conversations of other attorneys in the hallway, taking note of the specific language they used to defend their clients. Once inside, the magistrate asked why he wouldn't sign the acknowledgement. Ron stood his ground and actively refused the prompt. He told the magistrate he wouldn't sign because the debt was prescribed and subject to the in duplum rule, phrases he had just overheard but did not yet understand. The magistrate immediately turned to the creditor's attorney and demanded they produce the full documentation required to prove the case. Because the attorney wasn't prepared to provide that evidence on the spot, the magistrate postponed the hearing for 3 months. Shifting the burden of proof back onto the creditor buys a defendant a most valuable asset in a legal fight: time. Ron used his 3-month postponement to study the Magistrate Court Act and credit agreements, turning his hallway bluff into genuine expertise. This timeline for prescribed debt represents a legal expiration date, protecting consumers when creditors delay collection. The in duplum rule acts as a ceiling. When accumulating interest reaches the unpaid principal, it hits a hard legal cap and cannot grow. By the end of his legal battles, Ron had become so proficient in these specific laws that fully qualified attorneys began seeking his guidance. Intimidating legal terminology acts as a gatekeeping mechanism that falls apart once a defendant commits to self-education. Taking control in a courtroom starts with physically asserting your presence, bringing a pen and paper, actively taking notes, and asking direct questions. This must be followed by a focused drive to learn the specific legal rights that apply to your case. Ron's experience shows that the weight of debt shifts the moment you master the technical rules of the system.